Selecting judges, the whole nomination to confirmation process. It is very political. The first thing you have to consider when you are considering who you are putting forth to be a judge, if you are president, is that you want somebody whose judicial philosophy matches yours. The judicial branch is an opportunity, or nominating judges is an opportunity for the president to leave a legacy that will last long after he has left office. Some Supreme Court justices have stayed in office 20 to 30 years after the president has left, so it's definitely an opportunity for the president to make a mark on government. Judicial decisions have wide implications for policy. They interpret content of law, they interpret how it's enforced. They are the referees. They determine if the rules of the game are being followed. And like I said, their decisions have wide reaching effects. So there's a couple of things that you want to consider if you're president. Are you going to appoint judges that show activism? Judicial activism is a philosophy in which judges make bold decisions that change the public policy and law. Judges who are judicially active, they look for cases. They set precedent. They want cases that are going to shape the face of the nation. Now, these are your judges who want those landmark cases like Brown v. Board, Roe v. Wade, the cases that are really going to change public policy in America. Now, it doesn't matter whether you're liberal or conservative, you can be a judicial activist judge either way. If you show judicial restraint, this is a philosophy in which judges play a minimal role in making policy decisions. They look at the judicial branch and they say, we really should just do what the framers intended, and that's interpret the Constitution when it comes up before us. We shouldn't go out and look for cases to decide. Okay. Then you have loose constructionists. Loose constructionists use a lot of discretion. They are very flexible and open with the way that they interpret the Constitution. Often a judge who is a loose constructionist would be called a modernist, because this judge is going to look at the Constitution in today's culture and today's societal norms, and they're going to say, well, the framers gave us the groundwork, now we have to make the groundwork or the underpinnings fit our society. A president might look for somebody who is a strict constructionist, where they only consider the original intent of the framers. These judges tend to be called originalist, where they look at the text of the Constitution and interpret it as closely as they can to the words. In more specific terms, you can have literalists. Literalist to yesterday versus today. Literalists are going to take the Constitution literally, but they're also going, I don't know, here, this is kind of hard to say. Somebody who's a literalist yesterday is going to look more like an originalist. They're going to look at the Constitution word for word, and they're going to consider it in the 1787 terms. A literalist for today is going to be, they're going to look at the Constitution word for word, and if a modern issue doesn't fit into the Constitution, then they don't want to make a ruling on it. A lot of times judges will avoid cases that have political questions. That means they're going to avoid cases where the two branches of government are involved. These are cases where there's president versus Congress disputes. They kind of like to sit back and watch the political disputes, because they have loyalties to the Congress and to the president because they were appointed by the president, but they're also confirmed by the Congress and they can be impeached by Congress. Okay, the Supreme Court. Boy, if you get an opportunity to appoint a Supreme Court justice if you're president, you are in good shape. There have been 151 nominations to the Supreme Court. There's been 110 to serve. 29 have failed. Either they've died or withdrew their nomination. So it really isn't, I mean, if you think about the entire history of our United States, only 151 times have we been able to nominate a president and only a judge, and presidents have only actually got to put 110 on the bench or in the Supreme Court. Okay. Again, you have to, if you want to appoint a justice, you have to wait for a vacancy or for Congress to add a seat. Sometimes Congresses will take away a vacant seat and reduce the number of justices, and they can do that. When is Congress likely to do that? Okay. Congress is going to take away a seat on the Supreme Court if it's a divided government. So if the president is really liberal and Congress is really conservative and there's a vacancy on the court, that might freak out the conservatives in Congress, so they might take a seat away so the liberal president doesn't have an opportunity to make an appointment. Okay. So in FDR, he had to wait 5 years before he got to make an appointment. Nixon made 5 appointments, including a Chief Justice. Obama has made 2. Then you have Carter. Carter never got one. You're going to consider judicial philosophy. Judges are not supposed to be affiliated with the party, but they are liberal or conservative, and you can monitor that based on how they've ruled on other cases or the stuff that they've written while they've been professors at a law school, or cases that they decide to argue when they were lawyers. You're going to look to see if they are active or are activist, or if they are showing judicial restraint. Are they loose constructionist or are they strict constructionist? All of those things a president is going to consider when he is picking a justice. Another thing that he's going to consider is the demographic. There's been a lot of pressure in recent years to select diverse justices from diverse backgrounds. Most justices tend to be white males over 50, but the court that we have currently is pretty diverse. We have our first Hispanic justice, Sonia Sotomayor. We have 3 women on the court. That's the first time ever. We have 1 African American justice with Clarence Thomas. So it is pretty diverse. Experience. A president is going to look for somebody that has previous judicial experience, probably on the appellate, like the Circuit Court of Appeals, or the lower district courts, or even maybe somebody from the state Supreme Court with the background in constitutional law. The litmus test. Litmus test you hear about in chemistry. A litmus test is a question of whether something is an acid or a base. The litmus test when it comes to Supreme Court nominees is you're trying to determine whether somebody is liberal or conservative. So a litmus test is a question asked of potential judges, and the answer will determine whether the nominee would choose to decide a case in a liberal or conservative manner. So the litmus test, you're deciding, is somebody a liberal or conservative. Acceptability. The president is going to focus on people who can get a good review from the Senate Judiciary Committee. All right, they're going to make sure that the person is not too aggressive when they are getting reviewed by the Senate Judiciary Committee, and that they can answer the questions well, and that they have some appeal. You can't put somebody that's going to be too aggressive in front of the Senate Judiciary Committee and expect that they're going to get their nomination confirmed. We'll talk about that. That's the process of being borked. The lower courts. There are a lot of lower court vacancies and potential nominations. So the president needs some help. The White House staff can help the president go through federal judge nominees or potential federal judge nominees. It takes a lot to select qualified people and check their background, so the president uses the help of his staff to select people. There is the process of senatorial courtesy. This is a courtesy that's given by senators in a state to the president. Nominations to the lower courts must be confirmed by the Senate. Confirmation of district judges is often determined by senatorial courtesy, which means to ask the senators in a state that has a district which has a vacancy who that senator would like to be appointed. It is an unofficial tradition. Now, the way that works, so let's say we have a vacancy in the Eastern District of Virginia, so the Norfolk Federal Court. The president would probably ask Mark Warner and Tim Kaine, both of them are Democrats, so they're the same party as the president, who those two would like to see Obama appoint to fill the vacancy. It's a way to make the senators feel good because they're getting asked their opinion and they're providing an opinion to the president. Presidential checks prior to the nomination, they have a list of what potential nominees fit the president's ideology, and they'll decide and decide to pick somebody who might be moderate if there is divided Congress, or if they know that they could get away with it, they might pick a liberal judge. The FBI does background checks. They go through the vetting process, making sure that there's nothing wrong with you or that you've done something illegal. The Department of Justice, okay, they'll ask district attorneys, or the president will ask district attorneys who work for the Department of Justice if they believe a candidate is qualified because they probably have worked with them before. Now, the president's power over the whole nomination process is increased at the appellate level. The appellate level is going, a circuit covers a bunch of different states. So senators don't have senatorial courtesy here. They're a little bit weaker because, a senator represents one state and a circuit is going to cover multiple states. So the president has a little bit more power. Since there's more controversy, or this whole process is more controversial, it takes longer to be confirmed now. Senators of the opposition party used to be able to use the filibuster tactic to delay a vote. Presidents could use a recess appointment power to fill a vacancy. If the president wants to temporarily appoint a judge when the Senate is in recess. But again, when there is divided Congress, this whole process of nomination and confirmation is much more controversial.